I want to thank enormously Jan for the opportunity of being here and to discuss what it seems to me is one essential set of questions. The way in which I want to approach the hopeless timing is I will have 10 points each in 1.5 minutes, and hopefully this is 15 minutes. Then,
you took a minute to introduce them.
The key question is, whose constitutional imagination? When I get an issue and I don't know how to deal with it, I think which and whose. And the key question here is whose constitutional imagination? And this morning, the elites were here. I didn't see the people. Let's see if we can bring the people in. First point, legal theories and constitutional theories throw light, but also produce obscurity. It's not only that seeing is believing, I would say that believing is seeing. What you believe is what you tend to see. And this means that reconstructing the empirical material, the statutes, the rulings, and so on, I'm old-fashioned, I start with the statutes, through the prism of a theory emphasizes some elements at the price of neglecting others. The key question then is, what do the constitutional imagination account for? Does it provide the most coherent account of the things that we want to explain or not? Point second, the theories of European law and politics and the histories of European law, and then Morten will immediately react, but I think they keep on hinging upon a characterization of the process of European integration as constitutionalization, meaning the unfolding of a substantive program contained in the Constitution. So, for example, Cruz de Vilaça, some kind of judge, here to quote, constitutionalization is the systematic, teleological, and dynamic interpretation of the legal elements similar to that used by national constitutional courts. This is the idea in a nutshell. But this implies that you are accepting a certain conceptual framework, and this conceptual framework, I would say, is weak history, is progressive history, is optimistic history about European integration. Should we be optimistic or should we be Tories? And the following is sorry? In historical terms. If you don't want Tory, I understand, Mike, you can say Protean, but then it sounds very pedantic. So Tory, I think it fits the bill. What does constitutionalization boil down to? And I think this is a very interesting question because it seems to me it's like an empty container many times. It means whatever. But if it means something, it means 4 things at least. First, that European integration is a process that unfolds over time in which a normative vision is realized. So there is progress. There is this element, there is progress in the process. We go from A to B and we improve. Second, it implies that there is a constitution from the beginning, being the beginning either the writing of the treaties or Costa, Van Gen and Loos revolutionary coup d'etat, stone sweet type. This, I only say this and then I try to develop it, brackets empirical and normative questions, like how we got a constitution to start with. Third thing that it means, and I think this is key, is the equivalence, normative equivalence, to be more precise, between European and national law. This is why it makes sense to apply categories of national law to account for EU law. There must be some equivalence. They might be somehow equivalent, the two legal systems, but are they? The fourth thing is that constitutionalization implies a parallelism in terms of how things unfold with national constitutional processes. And you have the post-war, you write the constitution, and then you have the process of constitutionalization, that it soaks in, that it really starts to percolate into the legal system. So something similar happens at the European level. This is implicit. I have 2 first doubts regarding that. Using the Italian phrase, non tutto fa brodo. This is the first problem. So not everything is a constitution, not everything is a constitutionalization process. I cannot go into detail here, but very obviously, there is a formal constitution, there is a material constitution, there is a normative constitution, and moreover, there are very different conceptions of the normative constitution. What kind of constitutionalism are we talking about here? And for example, you have the very obvious understanding of constitutionalism, preparing for this, rereading Weiler, The Defense of the Status Quo. He says, our constitutions are about restricting power, not enlarging it. They protect fundamental rights and the individual, and they define a collective identity which does not make us feel queasy the way some forms of ethnic identity might. I don't have any problem with the last part. I have lots of problems with the first part. It sounds Hayek. It's not true that constitutionalization or constitutionalism is only about limiting power. It's also about constituting power, very obviously. A strange obscurity is my second doubt, because lawyers and judges, to quote Stein, and professors who favor what we call constitutionalization did not use the term. And this, from a historical perspective, is something that we should ask ourselves. Why is it that they were not using the term? Even if they knew very well about the term. Eric Stein was proposing constitution all the time. But I quote it in the paper, in '78, when he proposed a panel at the American Association, blah, blah, he said, oh, sorry, it's a Polanyish term. It sounds like a bit hopeless, one way or the other. Reality will catch up, and by '81, he could publish the article and succeed. But in '64, he was making the same argument after Costa, and he failed. It did not take root. Why it did not take root? Fifth point. I think we need to examine this, at least, in order to make sense of the term. First is cloaking in plain sight the question of who decided what, when, and how, to paraphrase Laswell. The things we look at, what is emphasized, is the result of projecting the very historical understanding that underpins EU law. And this is something that, at least I would say, I would ask the historians to liberate yourself from. Our own concepts as lawyers of constitutionalization. I think this is problematic. You should question us why you are, in a way, buying this kind of argument. For two reasons. The first is that we lawyers always tell stories and have histories. But they are the usable past. In Kastenstein, shame on him because he justified torture. But the key question is that it's interesting, his article about the usable past. We have a different understanding of history. We make history in order to make a case, to win the case, to be precise. But that's not history. That's a different story. So I think it's the second question is that the history does not go even into the legal details. So I would say Van Gen and Loos is direct effect of a treaty rule. But a treaty rule is not a treaty principle. And what we have now basically is the direct effect of treaty principles. And this happened in '67 on a VAT case is a scandal for the German judges that this is decided in such a way. I think they had a point. I'm not saying that they were fully right, but they had a point. But we have not been discussing these things. And this is the result of the use of this overreaching concept. The third thing is that it's terribly court-centric. And I would say, for example, that the first period of European integration was much more interesting to see what the legislator was doing. If you look about social security, free movement of workers, and this kind of stuff, is directives and regulations. It's not judgments. But we have forgotten about this legislation because we concentrate on the court. Sixth point. One of the reasons, I would say, the key reason why, and this connects very much with the paper that Marco will be presenting tomorrow, that the constitutional concept was avoided was that there was a very clear constitutional imagination that was a rival, a potential rival to this constitutional imagination, was national democratic constitutional law. That was very much related to the idea of the democratic and the social state, which in a nutshell, because everything in this presentation is a collection of nutshells, is Heller. Is the reconciliation between the Rechtsstaat, the democratic principle, and the social state that are in conflict but have to be reconciled. And this means mass democracy, institutionalization of the social conflict, power is not only limited but also constituted, and societal problems as a result as regarded as social problems open to be molded by intentional political decisions. And you have, for example, macroeconomics, among many other things. This was constitutional and constitutional at this time in terms of constitutional imagination. What we have to explain is how it is that something that is a very different animal starts to be labeled as constitutional. And we start talking about the Constitution when we were not thinking about talking about the Constitution, because the Constitution was the French, the Italian, even the German fundamental law. Even if it was not a Constitution, this would bring us into a discussion we cannot have here. Point seventh, Van Gen and Costa. I would suggest then we have to reopen them. And the key question, I was advancing the point so I can save time here, is that on the one hand, they propose a constitutional reading. On the other hand, the court introduces the narrative of the two legal orders. And they don't fit together. There is a tension there. I would say, as I said just before, is a matter of strategic pluralism. And I think Morten has been telling the story in great detail regarding why they were resorting to this strategic pluralism and how they were preparing this strategic pluralism. But it was sort of, that it was ambivalent, because on the one hand, it could be embraced on the basis of a democratic federalistic idea of the evolution of European integration, or it could be the Hayekian external constraint. And the ambivalence was there from the beginning. Second thing that I think it is important to reconsider in our way in which we tell the history of European law is the path that was not followed. We have overemphasized so much the decisions on direct effect and primacy that we have not realized the extent to which they were not followed, in a way. The key elements of the case law of the Court of Justice up to Cassis de Dijon were about non-discrimination. And non-discrimination, constitutionally speaking, is a totally different animal, because it implies a balance between integration and the respect of national socio-economic choices. And this is something that we have to tell and tell again, because this is a past that is very different from the present. The third thing is the ambivalence regarding, I can only select some topics, the ambivalence of Internazionale, which is a very strange case. Because on the one hand, it formalizes the concept of a deep normative constitution made up of the constitutional traditions common to the member states, but at the same time introduces the idea of a supranational yardstick of validity. And this is funny, in a way, because on the one hand, it goes back to national constitutions, but on the other hand, this legitimizes a supranational yardstick of validity, which for the time being, until Cassis de Dijon, was being filled with the very same contents of national constitutions. So, the obvious, Internazionale was about a collective good against private property. Collective good prevails over private property. This is not the Viking story. It's the opposite of the Viking story in terms of how you relate the two concepts. Last point, double or quits. We have not revisited properly the great shift, I would say, that happens in the process of European integration. At the end of '78, we have the European exchange rate mechanism introduced, so a new understanding of how we deal with monetary issues. And in March '79, if I'm not wrong, we have Cassis de Dijon. The two move the European Union from a common currency to a single currency. It starts the move in that direction, and the other moves the market from a common market to a single market. This is the shifting moment. It's not Van Ken and Loos or Costa. The shifting moment, if there is one, in which things basculate in one way, is 78, 79. And I don't have more time, but I have exhausted my points.
No, you have more time, actually, but thank you very much. Leaves us more time to talk about it. Very interesting, very stimulating. I mean, as a historian of concepts, I can only say after studying economists for some years now, I look forward to studying lawyers and the way they conceptualize their rationalities. Yes, Christian.
No, thank you very much, Agustín. I agree nearly with everything, and all I can say is I hope I have something to add which you don't know, because it's exclusively in German. It's a judgment of the German Constitutional Court from a time where they wrote in a decent way short text, great text, Investitionshilfe. What did the court say? Yes, the court said, you cannot annihilate this kind of economic activity, economic policy, because this is a matter for the legislature. This is a matter for politics. And now the move was, the constitutional move was, and this cannot happen at European level. The constitution of a democratic policy is one, as Helle had said, where the organization of economy and society is a matter of the legitimated legislature. Now, if this is constitutional, then you see, or it seems to you, I see it that way, how thin this idea of judge-made constitution is, which is only one which determines that economic liberty is subjected to what the legislature has said and so on. Okay, but this is deeply read, and what is true is that these kind of things simply get forgotten. Who knows Investitionshilfe, apart from a couple of people who know German still. But it's, I think, a fundamental judgment. For the rest, I would say the home idea of the whole idea of this type of constitutionalism is exactly what you capture when you always resort to Heller, because it was indeed the ordering of economy and society by a democratically legitimate legislature. And this cannot have an equivalent at European level. It's much easier to go into economic constitutionalism and to say this is what we can do and let's do it this way. Okay, I agree, as you say.
Morten?
No, I think responding a little bit to your Agustín about how to conceptualize this history of European law, but more from a historian's point of view, I think the attempt we have done, I think in the beginning when we entered the field, none of us were really legally trained, so we caught on to the Stein-Weiler school just as a political scientist did the first couple of years. And then meeting Michael Madsen and José and others, I think what developed from that encounter was really thinking out of the box and thinking it in a different way. And we, in 2012, Bill Davis and me introduced this concept, which was a bit unclear to us then, and hopefully it's a bit more clear in the paper I'm going to present in a second, about what we call a constitutional practice, where we basically see two elements: that the court engaged in a constitutional interpretation at a certain point in time with Van Gent onwards, and to a varying degree with different content, surely, but a constitutional interpretation, it takes some time before they admit it openly, but on the internal lines, it's quite clear what it is. And it comes out of a discourse in the 50s, and which is clearly constitutional, but then they change the word to autonomy, then they change the word to new legal order. So there's if you look at the legal service position in Bosch case in 61, they talk about constitutional elements. In the position in Van Gent, it's disappeared. So it's a question of strategic use of words here. But essentially, it's a constitutional interpretation. So that's one element of the practice. The other element would be a constitutional discourse. And there, I would say that breaks through with Stein and Weiler from 81 onwards. And why it happens there, I think, is a little bit an accident of history, to be honest. Because the question is not why Stein mentioned it, because as you're right, he says it in 64 as well, both in correspondence but also in his publication, that with Costa, the court has really taken a big step here that has these implications. But nobody really want to use it, right? But when we get to the Integration Through Law project, everybody suddenly jumps on. And why? Because of the Single European Act, because European integration has been invigorated. Now it looks as it might actually turn into what the prediction is, right? Or what the constitutional or ideological program was through integration through law. So what I want to say with this, now I gave you a small brush up, but the idea here is really not to say as historians whether it's the Constitution or not. It can be defined in so many ways that when you come from the outside, you realize there's no agreement. It can mean so many things. Constitution can emerge by process. It can emerge by a big breakthrough. There are so many ways it can come. How can we evaluate whether it's there in the EU today? I really do not know. But I think as a historian, what we can do is to see that there were a certain alliance of institutions and academics that wanted to promote that notion. And a big part of those actors, they did it because they wanted a European federation of some sort. They did it for political reasons, for professional reasons, for self-empowerment reasons. But that alliance promoted a constitutional interpretation, later also bought into a constitutional discourse. And that is, if you want to deal with the history of EU law, whether it's constitutional or not, and what kind of constitution it is, you just have to look at that social phenomenon. It took place. And it wielded a significant impact on how the history of European law developed from the early 60s onwards and into the 1990s onward, and then you take over in the 1990s, right? So that has been the attempt in a way to historicize the process, using constitutional practice as a description of a social phenomenon, not really as an argument whether European law is constitutional or not.
No, I understand that very clearly, but the trick is that the moment in which you use a concept that you are using it for historical purposes, but has very clear legal and political consequences, the concept is not innocent.
Nope.
Not even in the historical narrative. That's the problem. And the problem here, you say, Stein in 65 was using Constitution Treaty. It did not catch up. Weiler in 91 was not talking about the Constitution of Europe, was talking about the transformation of Europe, and then there were references to constitutionalization. But then in 1999 is the Constitution of Europe is the title of the book. I think something is happening, even so late. Something is going on. And this going on, and I think the concept can be used in very different senses, but still, I would still say that it has a normative, the reason why it's appropriated is because it has a normative positive value that is very much related to the national democratic constitutional law. Now the question is, should we use the concept in order to refer to a very different reality? And my answer is that even when you are doing history, you have to be aware of that. Because it also closes your eyes to things that should be looked into. Like, for example, how is it possible? Why? What is the kind of legitimacy that they had in order to use the term?
Okay, just a very quick response to that. The reason why it's constitutional practice and not some sort of other practice is for two reasons. It's really because, as a social phenomenon, it's very closely connected to federalism, European federalism. And for those politicians and actors that wanted to promote a federalization of the European integration process. So that's why if you want it, so constitution, it's not any sort of constitutionalism. It's for a big part of these actors, it's connected to European federalism. Not for all of them, not for all of them. So that's why if you want a descriptive term for those, for this social phenomenon, I do think constitutional practice fits the bill. But it's without any normative value judgment here.
But even if you don't want it to have normative value, it has normative value. This is the problem.
It's two in a row because we have a long list too.
Thank you very much, Agustín. It's so impressive to see you taking almost on a Foucaultian endeavor of having the archaeology of suppressed discourses and a genealogy of dominant discourse. Yeah? And I really liked it, and when you said concepts are not innocent, I thought, well, there he is, yeah, there he goes. But my question is, so I really enjoyed your paper. My question is, you return to Helen, and constitutionalism is the reconciliation between the rule of law and social solidarity. Where does this social solidarity belong? Is it part of which constitution is it? Is it political constitution, or should it be part of the economic constitution? Yeah? That because you criticize Hayek. Yeah? So if we disagree with Hayek that the basic norm of economic constitution is spontaneity, and we return to social solidarity, how it's to be promoted by the economic constitution, you only have traditionally one response: welfare state, administration and of redistribution of the welfare. And if you accept this, then the question is, how do you want to have the European economic constitution with so many different social welfare systems?
I have a footnote only, a short comment. I always found the term constitutionalization bewildering because originally we used it in a completely different context. We used the term constitutionalization to describe how a certain field of law was considered to be relevant for an existing constitution. The constitutionalization of criminal law. All of a sudden, criminal law is considered to be relevant for a constitutional tribunal, constitutional standards. This is how we used it before. It fell into the hands of European Union lawyers. Yeah. Then it transformed into something that is, if you look at it, so hard to believe. There's a field of law, it is created, and in its operation, it transforms itself into a constitution. Civil procedure, constitutionalize. Please, civil procedure, do something to constitutionalize. What do you have to do in order to constitutionalize it according to this conception? It has to become some form of higher law. How, and that's the interesting part, how do you become a higher law? By looking at the substance of what you actually regulate. And here is the mystery, the whole mystery of the irrationality, the magical moment actually in it. We owe it to the substance of what the European community law is all about, that it has to have direct effect and supremacy. So these are the two consequences to make it into higher law. Look at the substance. It was made in the interests of the people. Well, the Universal Declaration of Human Rights has all the more reason to be called the Constitution if you look at the substance of what it covers. Fundamental rights. Yeah? Tell your logical interpretation. Assume that Fernanda and I conclude a contract that we don't use our motorbikes at night so that either of us can get enough sleep. The purpose of this agreement is to provide for tranquility in our neighborhood. Well, that's the purpose. Everyone else in our neighborhood should be bound by it. This is the kind of crazy reasoning underlying it, yeah? And everyone believed it. Yeah, it's so easy. I'm having to say that. It's hard to get. Sorry. This was just a comment, yeah?
No, on the question of the reconciliation of the multiplicity of social systems and European integration, well, can it be otherwise? In the sense that, can you run a successful social system for 500 million people? The answer is no. There is hubris in thinking that you can do that. As such, the question is that what you can do, and this is something that was in the process of being made, and then we took a different path, is the question that you can have different social systems and you can make sure that you create the conditions under they can live together with each other and they can reinforce each other. Instead of competition between social systems, you can have coordination of social systems, which is good enough. You can then supplement, and you can have redistribution through different means. You can have common unemployment insurance. You can have many different kind of things. But that is the road that was abandoned at some point. And it has to do, let's be brutal, with free movement of capital. Either you have free movement of capital or you have coordination of national social security systems. And the world will not end the day that free movement of capital ends. It has already ended once, and the world continued, happily. Then on the question that Sasha was, no, it ended in 1914 by the war, and then it ended legally and formally speaking in 1945. There was financial repression, and the world did not have financial crisis for 30 years. Perhaps it's a good idea to do it again. What is so important about free movement of capital? I don't know. But Zizek said it. It's more easier to imagine now that the world comes to an end than free movement of capital comes to an end. And I'm puzzled by that. Then on Sasha, it's beyond the end of the world. But it's not. But it's not. Then the question, I fully agree. The most mysterious concept to me, in the same line as you were saying, the mystery of the Holy Trinity of European law is effet utile.
Oh, yeah.
Among other things, because effet utile, which we don't know what it means, but it's very useful. Effet utile. And then I don't know what it means. Effet. Then there should be a contrary to effet utile, which would be effet inutile. But
It's beautiful. It's the Trinity. Yeah, that's right.
it's the Holy Trinity.
Which of the three is the spirit? That's the interesting question. It's a fair
That's the spirit, yeah. That's exactly. Would you too also?
I have a clarification question. In the conclusion of your oral presentation, you seem to imply that 1978 is the moment in which there is a constitutional moment, a change.
Shift.
The shift. Is this really the moment of the shift, or is this a shift that anticipates the real shift, which is Maastricht, in your narrative? So it is the moment in which a process starts and it leads to Maastricht. The second question, I agree with you that Cassis de Dijon is a turning point, but I wouldn't agree. You seem to imply that it is a turning point because there is a shift from non-discrimination to access to market, obstacle-based approach. I'm not really persuaded by this. Don't you think that the change is more in the way proportionality is interpreted in that judgment? Because it is the first time in which the level of protection decided by the state is questioned by the Court of Justice. And finally, I was thinking about 1978, and it came to my mind that also another important judgment was decided that year. And it is a judgment that Jan and I have discussed a lot, which is Simmental.
Yeah.
And
Yeah, yeah.
the time in which constitutional courts are displaced from unity government.
Yeah, yeah.
This part of the plot, of the reason.
Yes, please.
Yeah, I'm actually totally in line with Marco's point. And in fact, I loved your formula, many things that you said, points, but it's cloaking in plain sight. A lot of what's going on is subterfuge and constitutional cloaking. So 2 points. One is, are turning points really turning points? And that's kind of that question. And more generally, you know, what is it about change and continuity in your story? How do we tell that story? Because at the end of the day, you know, we both believe in constitutions that are about order and stability of social order. I mean, that's kind of the point of a constitution. But at the same time, constitutionalization, as in Luke's story, is all about the not yet and the becoming from the court and the lawyers. So we have this little game of change and continuity, and part of the question is as scholars, you know, how do we relate to it? So, you know, I've argued, I've just published a piece on, you know, the constitutional, 20 years of constitutional settlement, that, you know, with Moravcsik, where the settlement was cloaked in the sense that it was in the most Cinderella of all treaty, the Amsterdam Treaty, and yet it was the most important kind of moment of establishing continuity in the EU. But I would say on Cassis and the single act, I've long argued that, in fact, Cassis is a turning point that's not a turning point, and that is not just because of how it was transformed by the single act and all the fallow directive, but the whole ECJ jurisprudence, both in goods but especially in services, was all about inventing or calling on states to invent a law around managed mutual recognition, which is all about recovering all the other previous concepts and reinventing the concepts and balancing and proportionality, etc. But what we have in the EU is managed mutual recognition. So change and continuity, and very quickly, my second point on cloaking is you know, very rightly kind of spoke about the court's trick of co-opting the constitutional traditions of its member states, and we will come back to this. So I was wondering what you think about the kind of Lisbon Treaty developments on the constitutional identity of member states and the way in which the ECJ has dealt with that, including in the kind of, I think, perverse effect that that has created a false homogeneity of the constitutional realities and practice, as per Merton, of the member states themselves, kind of pretending that there is no more kind of pluralist and oppositional narratives, etc., within member states, not that they have their one homogeneous constitutional identity that is recognized, but also re-narrated by the supposedly common constitutional tradition translated by the court.
On the first question of the turning point, the justification of 78, 79, you have things going on specifically at the European level that you can put your finger on. But I think if you look to the socio-economic history of Europe and of the Western world in general, 78, 79 is the pivotal moment, not only for legal internal reasons to the European Union, but in terms of where the shift takes place. It's the second oil crisis, is the move from a certain understanding of how we relate public power to socioeconomic issues and this kind of stuff. So I think instead of justifying it only by reference to the legal material reflects that change that is coming in many ways. In that regard, Cimental reflects also other cases. I was now, for reasons of time, summarizing a lot. But you have Luisi and Carbone, for example, that is coming before, or is coming around that time, and that are pointing into a certain direction. And then is when the European Court of Justice dares, in a way, to decide Cimental in the way that it decides. I think it fits into there was, if you look, for example, at the biographies of some of the judges and the advocates generals, I'm thinking Mancini. There is this shift. Then the other question, very briefly, because time presses. The constitutional tradition, the democratic national constitutional tradition, projects this element of the potential of the constitution in a different way from European law. In the following sense, you have, for example, the idea of material equality. This means in the post-war period that the constitution is not only about organizing power, but it's also telling what things in society should be changed in order to really realize the constitution. So you want to achieve things through the constitution. That's the reason that you do not only limit power, but you also constitute power. This is not exactly the same as on European law. On European law, it's more the question that we have a certain idea that we are going to be imposing in installments. So we have primacy, but we will not draw all the conclusions from primacy because this is judge-made law, so we will go case by case. That's different from the idea of a transformative program of society. It implies a radical transformation, but is hidden in the program. We are not saying that we are transforming society. National constitutions are saying we will change society. French, Italian, German societies are to be changed. And the Dutch and the Belgian that did not have that. Then on national constitutional identity and the court. The court and European institutions have basically tried to make of national constitutional identities a kind of Mickey Mouse concept. That is in order to introduce. So it's about Zu Wittgenstein and whether she can call her von or not von, or all these kind of things. The real concept of constitutional identity in these conflictual terms comes in OMT. And this is where the Advocate General of the Court of Justice says, oh, rightly, we cannot have this European Union if everybody has his own national constitutional identity and runs away with it. But then what's the point of national constitutional identity?
Okay. Just a very quick last one. Oh, please. Oh, you don't have to.
Or I will.
Yeah, please.
I don't have to, but I will. Agustín, you began by saying, you talked about elites this morning, and I'm going to reconnect with the people. And I didn't hear it. Tell us a story about the constitutionalization of EU law. Very convincing one. Brilliant paper. I more or less agree with the narrative. But then the question is why? Why did the Whigs prevail over the Tories? And in your brief response to Morton, we get a little bit of a sense, I'm not sure how much you agree with it, that behind this is a shadow of federalism. The one-time dream of Spinelli. Maybe that has some explanation. But what I didn't hear was in a sense, the Bickerton story, right? So why does this plot? I mean, because if you're not a Tory, I mean, you said to me at the start, you're either a Whig or a Tory. The Tories, of course, would love your Rasmussen story. It's all a big conspiracy, federal superstate. That's why there has to be a third alternative, and that would be the Bickerton story, which says, no, this takes part, this occurs through the power of domestic elites. And that's what I'm not sure where you stand on that point. Because you're in danger of pretending that's a story which sounds like it's an autonomous runaway train. But that's an odd story to tell if we take Bickerton seriously. This is a transformation of the state from below as much as it is from a bunch of lawyers in the fairy tale land of Luxembourg.
The people was coming in 2 points of the story. The first is national democratic constitutions, that's the people. And that's social rights. And that's the right to strike. There is nothing more people than the right to strike, I would say. In many ways.
Why do they let this happen?
No, wait. The second point in which it comes in the story is the idea of non-discrimination. Because non-discrimination helps in order to ensure that we have a socio-economic environment in which national constitutional projects can proceed, and at the same time, it was complementing national constitutional projects. If you were moving from one country to the other in order to work, you will have your social security contributions cumulated thanks to Regulation X from the European communities. That's something that happened because the issues that European law, including the European Court of Justice, was dealing with at some point were the problems of the transnational worker. That's the people, in many ways. I mean, I'm simplifying here because the workers are not all the people, but have to do with a certain understanding of democratic popular constitutionalism. It's not that I'm saying that it's a runaway train. I'm saying that at a certain point it shifts. And then the constitutional discourse that was very clearly related to democratic constitutional law shifts to something that was complementary, but it's not democratic constitutional law.